Thank you for joining us, Johannes Mokotedi. If you have a criminal record, you were found guilty in a court of law for some other offense, and you want to clean up your record, is that possible, or is it on your name forever and ever?
No, it's possible. I just want to explain the process. It's a purely administrative process wherein you approach the Department of Justice, you make an application, complete the form at their offices, and the form is submitted to the Director General, who will thereafter assess it and accordingly can issue a notice that your records be expunged. Now, what does it mean to expunge? Expunge is an English word which primarily means to erase or permanently remove. Now, the idea behind this provision is that for a convicted person to get a second chance in life, to continue as if nothing has happened, for him not to be denied for, any other opportunities. Now, remember, there are conditions and there are certain requirements which a person must meet before he can qualify to make such an application.
Yeah, surely they're fairly strict. I mean, you can't commit, if you're found guilty of murder, for example, yesterday, you can't on the next day or week after that or whatever apply for the record to be expunged. No, it's only for certain offences and after a certain period of time.
Yes, correct. Firstly, 10 years must have elapsed after you have been convicted.
For all the offences.
Yeah, for all the offences. But I'll come and explain the kind of offences and you can approach the director for such a expungement of the records. It should be noted that firstly, the process to start by approaching the local criminal center for the police, wherein they will issue a notice indicating that your sentence has now exceeded an amount of a period of 10 years. As such, you are eligible to make such an application, and it can only apply for certain offenses. For instance, if you have been sentenced to a period of imprisonment without a fine, you will not qualify. But where there is a fine, you will qualify. If it's a corporal punishment, you will qualify. If there is a what we call this house arrest or correctional supervision, you will qualify and end. But for a person to actually clear out and to make sure that you do qualify, the Act makes provision. There are certain Schedule 1 and 2 offenses wherein you have to check that you can qualify for making such an application and or not.
All right. So it's the less serious offences, obviously, that apply. But the time period is always 10 years. So after 10 years, you can bring such an application.
Yeah, after 10 years, you can make such an application. Take note that it is purely administrative and it is with the Director General. He can, however, delegate such an authority to any other person. Practice has told me that they normally appoint an attorneys who will do such work for them and make a recommendation, and the director will only make an endorsement. And it should be noted that it takes at least 3 months. Therefore, after making an application, you cannot make an inquiry after or within 3 months. Therefore, you must allow 3 months to pass for you to be able to make an inquiry. And in addition to that, if the director is happy that your application conforms to the requirements of the Act, they will issue a notice indicating that your records have been expunged. Such a notice will be issued within a period of 14 days. And you take such a notice, you take it to the Criminal Record Center, and the Criminal Record Center will within 21 days expunge your record. And your record will be as if you have not committed that offense.
So do they still have a discretion to grant the application, or is it sort of automatic? If it's longer than 10 years and that category of less serious offences, then you automatically get it if you apply, or do they still have a discretion?
No, I think as long as you conform to the requirements of what they require, you will automatically get it. However, administratively, it's a cumbersome exercise. A person has to exercise some patience. And it should be noted that we lawyers do such applications on behalf of clients. Obviously, it is at a fee. However, members of the public can approach the Department of Justice directly in Pretoria complete such forms. It's free of charge, and take it from there.
And then your record is clear. So if you thereafter apply for a job, for example, and they check your credit, they sometimes check your credit record as well. But if they check your criminal record, then that would be clean. So they wouldn't pick up anything on your name at all.
Yeah, it will be thin and you'll not pick up anything. However, I don't know, but I prefer to be on the safer side of it, that when you make an application, to tell them that you were before convicted, however, such a record has been expunged.
Sure.
Just to be safer, because of administratively, it can happen that your records have not been updated and you didn't disclose it, then it has other implications as well.
And then serious offences like murder, rape, etc., those cannot be expunged.
Yes,
they remain on your name forever and ever.
Yes. However, for sexual offences and for certain types, remember that the court can also make a further endorsement that your record reflects on the register. Before you make such an application, you have to approach the Criminal Record Center that your name be removed from the register, which is, however, a different process, and you'll have to come up with a proof that it has been removed from the register. Otherwise, your application will not succeed.
Okay. Thank you.
Thank you.